Today again to join you all for Q&A session, all things employment law. My name, of course, is Chris Justice. I'm an associate working out of the Toronto offices of Samfiru, Tumarkin. And as I mentioned, I'm here to hopefully answer, as I always do, as many of your questions as possible. So please do send them in through the chat. Anything at all, I'll do my best. And as I normally do at the beginning of each of these sessions, I've got a few topics that I just want to touch on. This time around, I'm going to quickly talk about a couple of stories that were in the news or have been in the news recently that have some employment law issues that I think everyone ought to be aware of, whether they're in a similar position or not, or just going forward so they're armed with as much knowledge as possible. So the first topic, the first story that I'm going to talk about today has to do, I'm sure many of you might have already heard, with a restaurant by the name of Freshie, a fairly popular, prominent restaurant within the city, within the city of Toronto, that is, at least. And actually, they have hundreds of locations across all of North America. And recently, there was somewhat of a controversy, or they came under a bit of flack for having this virtual cashier type of a position where essentially Freshie is outsourcing work to Nicaragua to sort of help deal with its customers here in Ontario. And so just quickly to explain the virtual cashier concept, there's a video calling device that gets activated when someone looks to check out some products that they're looking to buy. And a cashier can be made available to answer any questions that the person has before cashing out. And as I mentioned, Freshie has been outsourcing some of its virtual cashier positions to places outside of both the province and the country. And I mentioned Nicaragua. And there was some controversy around this because while the minimum wage here in Ontario is $15 an hour, in Nicaragua, it's actually $3.75 US currency. Excuse me. And so there was a lot of outrage by a number of people who thought that Freshie were essentially taking advantage, maybe not paying its employees enough. And so there's definitely been some negative feedback in that sense. And I just kind of wanted to talk about the idea of companies outsourcing their employees to or the work to other countries, and as well what kind of an impact this would have if you yourself were in a position where, let's say, you worked for a Toronto-based company, but outside of the province or even outside of the country. So first of all, the question of whether or not a company can outsource work to other countries, the answer is yes. On the face of things, Freshie is within its rights to outsource work. And when it looks to hire workers in different countries, then there's a likelihood or a chance at least that, of course, they're going to adhere to those, the laws in that particular country. So if the minimum wage laws are different comparing Toronto to Nicaragua, it's not to say that Freshie can't do that or that a company can't do that. That being said, just because you are somebody who works outside of, let's say, an office that your company is located in, does not necessarily mean that the laws of the country that you're living in are the ones that take precedent. So generally speaking, just don't assume that where you're working is what law is in effect, what law governs the relationship. Because there are definitely circumstances where people work outside of Ontario, they work outside of Canada for, let's say, a company that's actually based in Toronto, but they still are obligated to comply to some part or entirely to the laws of Ontario or of Toronto or of Canada. So that's number one. Don't assume that, where you are is the governing law. And actually, one other place to sort of look to find out maybe what law does govern your employment relationship with your company, one place to look would be the contract. Normally, when somebody signs a contract for a job to start a job, there normally is a section in the contract, usually near the bottom, that talks about what law is governing that contract. Is it going to be the laws of Ontario? Is it going to be the laws of British Columbia? Or is it going to be the law of some place outside of the country altogether? And so I think that's an important part to look at for sure, because that could determine what laws are in place and therefore what your rights are. And these could be rights that relate to just the working conditions. These could be rights that relate to how much severance you might be owed if you lose that job. Like, say, for example, your employer is outsourcing a bunch of work to India, and as a result, you're losing your job. Well, first of all, you definitely will be entitled to severance of some sort in all likelihood. So you'll want to get in touch with our firm to assess how much severance is payable, as is normally the case. But secondly, sometimes there are issues when companies outsource to other countries, where they actually ask the employees who are based, let's say in Toronto, to train their replacements, for example, say in India. And a lot of employees take exception to having to train their eventual replacement. And in some circumstances, being forced to train your eventual replacement could actually be a termination in and of itself and could entitle you to severance from that point forward. In other cases, the company can be within its rights to ask you to train a replacement. So it kind of depends on the facts of each case, but also don't assume that a company cannot ask you to train a replacement, because again, there are those circumstances where you're actually obligated to do that before you leave. But at the same time, just know that there might be some options. So if you're in a situation where you've either lost your job due to outsourcing, where you're being asked to train a replacement that's perhaps located outside of the province or the country that you live in, or you're just wondering about what law governs the employment relationship, especially if you're working somewhere else and the company's main office is located in a completely different area. Any one of those three scenarios, these are all situations that I would recommend getting legal advice for. And again, contacting our firm to get that advice, because again, you're going to want to make sure that you sort of do everything's necessary and not do something that may later on come back to haunt you or affect your case. So all the more reason to be proactive in these situations. And not to mention, of course, it's just good to be as aware and mindful of all the different factors that may be at play, depending on what situation you find yourself in at a later date. So that was my piece on Freshie. I'll get back to some of the news or some topics later on in today's session. I do realize we've got a question in, though, from M. Ellie on YouTube. So I'm just going to address that question first and any others before getting back into some of the stories I was going to talk about at the outset of today's session. So M. Ellie, first of all, thanks for reaching out. Thanks for bringing in your question. Just to read it, M. Ellie is saying that they read a CBC article in March that the Ford government lifted the vaccine mandates, including for long-term care workers. If this is true, can you assist non-unionized long-term care workers who were put on an unpaid leave for refusing to get vaccinated? And again, thank you for the question. The short answer to that question, M. Ellie, is yes. We can likely be of help in your situation or in situations involving non-unionized workers that work in long-term care homes. What you've mentioned as far as the government lifting the vaccine mandates is also important to recognize, because yes, there was a change when it comes to long-term care homes as far as the legislation was concerned. And depending on your particular situation, that change might actually work to your benefit and may actually result in more severance being given your way. So yes, definitely you'll want to contact us if you're, frankly, any employee who's been put on an unpaid leave for refusing the vaccine. You'll want to contact us, because there's a good chance that you'll be entitled to severance, even though there are certain risks present and we're not exactly clear on how the law is going to land on a lot of these issues. There's still a good chance that you'll get the severance. So for that reason, give us a shout. And again, if anyone else is in those situations, whether we're dealing with long-term care homes or a different employer altogether, definitely get in touch with us if you've been placed on a leave without your consent for refusing to get vaccinated. So thank you for that question, and perhaps we can help you out in the near future. Christy Ends on Facebook. She's got a question, and she's saying that her LTD, her long-term disability benefits, is switching to CPP as a result of a permanent disability that I take it she sustained. And she's also mentioning that her LTD will top up, I guess, meaning that whatever CPP contributes, if that's less than what she was getting through her long-term disability benefits, the disability benefit insurer will kind of top her up so that she's back at that 100% or whatever the threshold might be. Chrissy's asking, is this the point where my major automotive employer will sever me off? So I think, Christy, what you're saying is, are you at a point now with your employer, because your disability is permanent and not likely to improve? Does that mean that your employer is eventually going to terminate your employment because it can't perhaps figure out a way to keep you actively working there in light of your disability? And the answer to that question is very well, that could be the case. Your employer usually has to wait some time if you're off on a disability and unable to do your job before it takes any kind of action as far as cutting ties with you is concerned. So, for example, if an employee is unable to work as a result of a disability, the employer cannot simply terminate that employee's employment right away. They've got to generally accommodate that employee. They've got to generally follow up with that employee and find out maybe if there's any update or if there's any hope of that employee coming back. A lot of times the doctors will get involved and give their opinion as far as when a potential return to work is concerned. However, employers also don't have to keep your job open forever. There will come a point in time, if enough time has passed, and a lot of times it could be 1, 2, 3 years. If nothing has changed after several years, for example, and at that point your doctors are still saying that there's no hope, I guess, of a return, or that the prognosis is very poor and there's no sense of when they'll come back, then at some point your employer will be able to say, you know what, we've held your position open for as long as we can. It's been several years now. We've been told by your doctor that things are just not going to improve. And unfortunately, we cannot just keep your position open indefinitely. So therefore, we're terminating your employment. So that can happen. It comes down to each situation as far as how much time they need to wait before taking an action like that. So Christy, maybe in your circumstances, it's more reasonable for them to wait a few years versus maybe less than that. But if the takeaway is still that you're not able to go back to work, then definitely your employer could allege what's called frustration of contract. And if they allege frustration of contract, there is typically an amount of severance that is owed to you regardless, and that would be based on your years of service being one factor. But as long as they comply with that minimum amount, your employer may not necessarily have to pay more than that in terms of what you might be owed under the common law. So again, it'll come down to a case by case basis rather. So I don't want to say one way or another exactly what will happen in your case, Christy, but yes, there is a point in time where they may cut ties and they may offer you some compensation at that time. They may not offer you compensation at that time. If that time comes and that's what they do, whether they offer it or not, I definitely do suggest that you get in touch with us and we can at least make sure that what is being offered to you is fair. We can give you a better idea as to how reasonable your employer is being in your case, because a lot of times, frankly, employers are a bit too quick to jump the gun and cut ties with somebody, and they don't give that person enough of a chance to recover or come back. So yeah, you'll definitely want to maybe give us a call, Christy, and we can flesh out some of those details, and either way, give you the advice that you'll need. But thanks for your question. I think it's important just generally for those who've been off on disability and are wondering how long their employer may have to keep their job open for, or perhaps also how much communication there needs to be between you and your employer. A lot of times when somebody's off on a disability leave, they, for lack of a better word, get harassed by the company. They get messaged by the company, emailed by the company every month looking for an update. And it can be a very stressful time. And it's not necessarily the case that that's reasonable for the company to do. It'll depend on what the doctor's saying and what the recovery period is like. But if you're also a person that's in a situation where you feel like you're being harassed by your company while you're off on a disability leave trying to get better, that could also be a major issue and something that is probably worth talking about. And again, kind of fleshing out and seeing what can be done, what your options are. But again, Christy, thank you very much for your question. Hopefully that answered it. Going forward, I've got another question from Bubba on YouTube, who's saying that they are working as a trainee and they're waiting for a letter so that they can deduct their SAW from their taxes. It's been a few months and no one has said anything. So Bubba, just so I'm clear, I think what you're saying is that you purchased a SAW or acquired a SAW in order to do your job, and you're looking for documentation from your employer so that you can claim a certain benefit or recovery of money based on purchasing that SAW because it's work related, I think is what you're getting at. And yeah, there are definitely ways to, I guess, save or benefit from purchases made that relate specifically to the workplace. This could be a SAW. This could be a home office. Now that a lot of people are working from home, and not to deviate too far from what you're talking about, Bubba, but now that people are working from home, they've had to perhaps purchase a desk or a chair or a computer that may not have been required before. And so they've incurred that expense. And just like your SAW, in a lot of cases, they can claim that expense on their taxes to get a benefit. Bubba, I would say if you've been following up with your employer about getting this document so that you can claim a recovery on that purchase, I'm wondering if you've sent anything in writing in an email. I would definitely paper the trail, ask for it in writing, ask that they give you a response by a certain deadline. If still no response, it's going to be a question of what benefit you're losing out on and how much that's worth, I would imagine, before you want to decide whether you're going to leave that company or not. Definitely you'd want to think about that. But I would say put it in writing, do it a couple times if you haven't already. And if you're still not getting any word, maybe give us a call, contact us directly, and hopefully we can at least give you some more options on how to resolve that issue. It seems like it should be fairly minor, but for whatever reason, it seems like you're also getting a bit of a tough time from them in terms of a response. But yeah, definitely get in touch with us. And if you want to reach out to me directly, Bubba, I'm happy to follow up and hopefully resolve that issue. But thanks for your question. I've got another question or comment in from Hans on YouTube. He's saying that he was hired on January of this year, 2022, and terminated on April 14th. So approximately February, March, April, you've got about 3 months. Actually, they terminated you, you're saying, just before the 3-month probationary period. And then you had a follow-up question, Hans. Does it mean that in past probation based on the weekend and holiday on April 14th? Not clear what you're meaning by that, but what I will say in your situation, and this applies to anyone, if you're an employee and you have accepted a job and then you were terminated from that job within the probationary period, you may think that you're not entitled to any compensation. Maybe it's because your employer has told you that. And even though you are working or were working for a short period of time, and even though you may have been terminated within 90 days or 3 months of your time there, yeah, you just don't want to assume that you're dead to rights, that there's no hope of you getting any severance, because there actually have been cases that have happened before where employees with a month or 2 or 3 months of actual service with the company ended up getting several months of severance, believe it or not. So even someone with a short amount of time as that could potentially get several months of severance. And so definitely want to take into account that. You may have a contract that you signed, and the contract, Hans, may talk about a probationary period, and that would definitely factor into the equation. If there is a contract and the contract talks about what the company can do in terms of terminating your employment before your probationary period ends, then there is a possibility, based on how that contract is worded, that an employer could terminate your employment and not owe you anything, depending on what the contract says and how long you were working there. But even if there is a contract as well that talks about probationary periods, you also still don't want to assume that it'll actually have effect. So it's one thing for there to be something on a piece of paper, but it's another thing for that piece of paper to actually do what it says it does or have the effect that it says it has. So that's number one, Hans, is you don't want to assume that you're owed nothing there, and you could be owed some severance. But another point I just want to raise, that I thought about in terms of what Hans is saying. If you're an employee, and let's say you have a job with one company, and another company comes to you and says, "We really like you. We want to hire you. And so, and we're willing to give you all this money and benefits," and they really try to entice you, incentivize you to come and join their company, even though you're working at the first company. Let's say you leave this company and you go and join the company based on these promises, based on the financial incentive, etc. Well, you just left a job that you had that was secure, and you've taken a chance and you've joined another company. Now, let's say you end up getting terminated from the new company very quickly. You possibly may be able to get severance from the new company that hired you, but also to take into account all the years you had with the previous company. So, for example, let's say you're with one company for 10 years, you leave that company based on promises made by another company, and then you lose that job within a few months. You could potentially get severance as though you were with the new company for 10 years. There's a term called inducement, and that's when one employer essentially induces you or incentivizes you to come and join or leave one company and come and join their company. And in cases where inducement is present, where it exists, that's where an employee could potentially benefit quite greatly from maybe the previous time that they had with the company that they left. And so you don't have to necessarily feel too hard done, because the court could recognize your service with a completely different company in particular circumstances. So whether you were induced or not, Hans, or whether you're just looking to find out what you're owed in terms of severance potentially, even though they let you go within the 30-day or the 90-day period, get in touch with us. We can tell you either way what your options are, what you could potentially be looking at, and go from there. Because again, your potential entitlements could still be significant, even though you're an employee with just a few months of tenure with a company. So that's just a general point for everyone. Hans, you also say that they posted another job in Montreal for the same duties, and that they wouldn't tell you why you were terminated. So normally, an employer doesn't have to give too many specifics in terms of why somebody's terminated. A lot of times, companies will simply say that you're not the right fit, or we're going in a different direction, or we're just not as satisfied with your performance. And for the most part, those explanations, those reasons for termination are good enough. Companies don't need specific reasons to let you go, as long as they're not terminating your employment for discriminatory reasons or in extreme bad faith. They can pretty much use any reason they want, as long as it's tied to some business rationale or business reasoning. It's unfortunate. It seems like that they're not giving you a full idea as to why you were terminated. And all I would say is that if you believe there is foul play or there's bad faith or discrimination, that might be something you want to investigate or look into further. And that might also be something that we can help out with. But if that's not there, then there's a good chance that the company will be able to do that, but still may have to pay you severance. So it doesn't necessarily mean they don't owe you severance. It's just that in terms of any additional compensation for why they let you go, it would be, a much harder battle or a much more uphill battle to fight. But either way, Hans, you may want to get in touch with us. whether it's online or over the phone, and we can set something up and go from there. But thanks for your question. I think that is also one that can apply to a lot of different people. I've got another question in from Teresa on YouTube, and Teresa is saying that she was let go back in October of last year because she chose not to get vaccinated, and she was with her employer for almost 17 years. She's asking whether or not she has a chance to get her job back. And she's also saying that there's currently no vaccine mandate or mask mandate. And again, asking, can I get my job back so I can retire how I deserve to retire? So first of all, Teresa, it's unfortunate that you were let go. Now, when you, Teresa, say that you were let go, I guess my question is, did your employer actually terminate your employment in by putting it in a letter, let's say? Or did your employer say that you are being placed on an unpaid leave of absence until you get vaccinated? Because if your employer has put you on an unpaid leave of absence, it may be possible to get your job back. Now, what are the odds that you're going to get your job back? Hard to really say. In my experience so far, unless somebody gets vaccinated or unless the company completely changes its vaccine policy or gets rid of it, and again, this is from my personal experience dealing with various clients, it seems very unlikely or very rare that a company will have you come back to work. So you may not actually have much of a choice there, even if you want to go back to work. Having said that, if there is no hope for you to return to work, and if you have lost your job because you chose not to get vaccinated, there is an ability for you or a possibility for you to treat that like a termination. And if you've been terminated, normally you're entitled to severance. And so if you can't go back and retire as you would like to, I think at the very least, given the 17 years that you've put in, you want to try as best you can to at least get some severance to compensate you for the years of service you put in, especially if there is no law that applies to your organization or that organization that says people have to be vaccinated, because that's another big part. And Teresa, one more thing I'll add is that if you can do your job from home and there's no need for you to really interact with anyone as far as these concerns about COVID-19 are concerned, then that could be another relevant factor. And again, this applies to everyone. If you have lost your job due to not complying with a vaccine policy, but you've been doing your job from home 100%, say since COVID started or for a while, that can be a very beneficial factor in influencing the outcome of your case and getting you severance. Sorry, Teresa's just following up. She said she was sent a letter and she was given a chance to appeal her termination like in a trial. And she's still waiting for an answer. So Teresa, I'm not, that sounds unfamiliar to me for an employer to terminate your employment, but give you the opportunity to appeal. I wonder actually, Teresa, if you're a unionized employee or not. And I will just make a quick point regarding unionized employees. For the most part, we don't do that work, and you should look at your, speak with your local union rep and look at your collective bargaining agreement. That would probably have answers as far as your ability to appeal a decision is concerned. So again, Teresa, if you are in a union, you'll want to talk with your local union rep and look at the collective bargaining agreement. That should give you hopefully most of the answers in terms of what your options are. If you're non-unionized and you've lost your job one way or another for not getting vaccinated, I still think you should pursue that to some degree and find out whether and to what extent you're owed severance. Again, especially seeing as how long you've been there. So Teresa, I would say if you're non-unionized, give our firm a call. We'd be happy to set up a consultation and take you through some of the steps or the options that you might have, and hopefully just maximize the amount of severance you can get. And sorry, Teresa, I'm just hearing that you did speak to the union and they're not doing anything for you. Unfortunately, it's a tough one. You're going to have to essentially file what's called, I think it's an unfair representation claim against the union for not, from your point of view, doing its job. Now, I will say that the odds of succeeding in these types of claims are very low. So it is a difficult thing. I would just continue to see if you can present a grievance, if you can get your union to present a grievance on your behalf towards that company, because that's realistically the one main thing that you can do. Again, I can't be of much further help to you, but I do hope that your union can do something and at least advance a grievance on your behalf. Having said all of that, I do appreciate everyone's time. I do have to go. We have reached the 30-minute mark. But as always, give us a call. You can phone us up. You can contact us online on our website as listed below there. And otherwise, you can just stay tuned for more Q&As, which, of course, we're going to be having on a regular basis ongoing. So thanks again for everyone joining me today. And I will be back and ready to answer more questions very soon, I'm sure. But do take care until then. All the best. Bye for now.